Good morning. Welcome to the Land Use and Transportation Committee meeting. I am Ryan Dorsey, Chair of the committee and representative of the 3rd District. Today, the committee will hear Council Bill 25-0006, Zoning Code Modifications. In attendance today, we have my Vice Chair and the Vice President of the City Council, Sharon Green Middleton from the 6th District.
Thank you, Mr. Chair.
To my far left, we have Councilman Zach Blanchard from the 11th District. To his right, we have Councilwoman Felicia Porter from the 10th District. To my far right, we have Councilman Mark Parker from the 1st District. To his left, we have Councilman Paris Gray from the 8th District. We have our staff here, Tony Leva. Good morning, Tony. How are you doing? Good. Thanks for putting this whole packet together for us. It's a lot of material that we have here. We have representatives from the mayor's office and various city agencies who will introduce themselves in time as they are called upon. The bill before us this morning is lengthy. It is 28 pages. It puts forth about 30 different changes to the zoning code. There are also 24 amendments. 14 are from the planning department. 13 of them are kind of substantive, and one is purely technical. Some of them are arguably more technical generally. And we have amendments from myself, Councilman Parker, Councilman Blanchard, and I think we will hear from Councilwoman Odette Ramos or Councilman Jermaine Jones, who are not members of the committee but do have an amendment that I'll allow them to present when they arrive. We have done considerable work here to really grasp what's in the bill. You'll note from the planning department amendments that there are a number of things that are kind of corrective. I think this is demonstrative of the diligence that many people have put in to make sure that all the little concerns are being caught and that additional greater concerns that can make things work better in the city have been brought up through some other additional amendments. In the interest of trying to get through this, I'm going to kind of talk us through this mostly myself. But I want to, this is originating as an administration bill in the planning department. I want to ask Tyler Schnella and Eric Tiso if they want to make any beginning remarks here. Okay, all good. I will do some bill reports here real quick, if we can just keep it brief. Before I do that, I want to recognize Ben Gothorn, the director of the Department of Legislative Reference, who has done an incredible amount of work in drafting this bill up, as well as a lot of different amendments, and just really want to thank him for all the work that he has put in on this, helping so many of us. Let's go through bill reports real quick. Law Department.
Good morning, Chair Dorsey. Jeff Hochstetler on behalf of the City Solicitor's Office. Law in its bill report noted that it could approve the bill with a minor amendment. Those suggested amendments are incorporated in the amendments that you will talk through in a little while. So Law can approve this for form and legal sufficiency.
Great, thank you. BMZA, Becky?
Becky Witt on behalf of BMCA, we've submitted a favorable report.
Great, thank you. Do we have HCD here?
Thank you, Mr. Chair. Jason Wright, representing the Department of Housing and Community Development. We stand behind our favorable bill report.
Great, thank you. Parking Authority.
Thank you, Chairman Dorsey. This is Fran Bernsinski with the Parking Authority of Baltimore City. We have a favorable position on the bill.
Great, thank you. Legislative Reference. Anything, Ben?
Good morning, Mr. Chair. We do not take positions on bills.
Great, thank you. Planning Commission.
Good morning, Mr. Chair, members of the committee. Eric Tiso for the Planning Commission. We have a favorable report for you with 14 amendments. Happy to walk through them whenever you're ready.
Great, thank you. And as we know that the Planning Department is incorporated into the Planning Commission's amendment, I will spare asking you what the Planning Department's position is. Okay, so let's, again, I'm going to try to talk us through this bill myself, since I've spent so much time with it over the last few weeks. I feel like I've got a pretty good grasp here of each of the different proposed changes in the bill, as well as a fairly comprehensive understanding of the amendments that are being put forth It does mean I'm going to have to kind of flip back and forth here. Let's see here. Okay, great.
Okay.
Of note also, committee members, as you'll remember, each of the different changes proposed throughout the bill has an explanatory note. Thank you to everybody who worked on those explanatory notes to make sure that it's easy for us all to understand what's in this bill. The first section here, the explanatory note, tells us that this text was retained from the prior zoning code in error. Before the comprehensive rewrite of the zoning code, the use tables at the back of that edition were unofficial and for readers' convenience only. Essentially, the old zoning code had tables just to make it easy for you to understand everything else that was written out in text in the code, but the tables themselves were not a codifying element. This new zoning code, as of the end of 2016, uses tables as a codifying standard throughout the zoning code. And so this fixes one holdover provision that was not changed from the old zoning code to clarify that the tables are in fact codified and hold weight in and of themselves. Any questions in the committee about that?
No.
Okay. The second, on bill page 3, we see a section on line 11. There is an amendment from the planning department to change the word variances to the word definitions. This is clearly the word variances was a typographical error in the zoning code. It should have said definitions here. It's just correcting a typo. The next section from 12 through 21 modifies the definition of government facility to add to it the inclusion of recreation outdoor on line 19. I have an amendment for this to strike that, to negate this. I requested an explanation from the Department of Recreation and Parks as to why they wanted this added in here. They did not provide any explanation. I believe I know why they want it in there, and I disagree in principle with them. And so I have an amendment here, since they couldn't even bother to explain to us why they want it here, to simply strike this to negate the whole purpose of this being in the bill. However, there is another amendment to this from planning. Amendment 3 from the planning department adds to the end of this where it says on line 19, and utility facilities. It changes that to say facilities that are operated by a government agency. The purpose of this is that, for example, earlier in that line, at the beginning of line 19, it says recreation indoor is a part of the definition of government facility. However, there are plenty of recreation indoor sort of facilities that are not run by the government and are not government facilities. This addition in the planning amendment that says facilities that are operated by a government agency simply clarifies that the only recreation indoor and such that are actually part of the definition of government facilities are those that are actually run by the government. Any question about that? Great. The next section here. Title 3, Subtitle 2. So beginning at the bottom of page 3 and going on to the first half of the next page. Eric, do you want to talk about this a little bit?
Sure, so these are 3203 changes. There are some trigger lists in the zoning code for specific reviews, for site plan review, for design review specifically. And so we look at that list to see what development requires those reviews respectively. Also, I'm sorry, this is in the duties of Planning Commission. There was a line in there that required us to update the zoning code every 10 years, which we would be just about hitting that 10-year mark. And instead, what we are looking to do is to have an annual group or bulk rezoning. Technically, it might fall under the term of comprehensive rezoning, but when you say comprehensive rezoning, that may confuse folks in thinking that we're going to do the entirety of the nearly 70,000 parcels across the city. That's far too much. The intent was to try and streamline the process, have folks apply in a window opening all at once. We typically see about 15-ish bills per year for rezoning. And instead of seeing them one at a time and going through the entire process one at a time, we believe it would be better to see them in parallel. This will do a couple of things. Number one, it'll reduce the cost to the applicants because they can join in a single administration bill instead of having to pay a few $100s on drafting each. It'll also focus the attention for communities into a group process to see all of them at one shot. And it will hopefully lead to less effort on their parts and will allow us to cross-compare to see if one possibly affects the other instead of just looking at each one in isolation. Of course, this doesn't change your ability to introduce an individual piecemeal rezoning. That's not going away. You can still do that. So if there is one that is of particular concern to you, it can be amended out and can be taken separately if that's a concern. If there is somebody that can't wait for the annual rezoning window, they have the opportunity to apply for a piecemeal rezoning with the understanding that the required findings for some form of change or mistake, which is a high bar to find, will be necessary at that point. So we hope that is the carrot and stick there to do it all at once. Additionally, it asks us to do a quadrennial update to the land use map, which we now have adopted as a part of the comprehensive plan that was adopted this past December. This is something that we're required to have as part of the comprehensive plan. And I think I've mentioned this before, but if you were to kind of stand back from the zoning code and squint a bit, that's sort of what the land use plan looks like. In each of those general land use districts, it is a collection of related zoning code districts. And so where before we had nothing really to compare against to answer the required findings of how does this really compare to the comprehensive plan. Now we do. So going forward, we're going to be encouraging people, you have to be careful when you do this because now there's some guidance to how we do this. You're going to have to compare against that land use plan. So that's the purpose of those changes.
Great, thank you, Eric. So in short, these just modify the list of powers and duties by the planning, to be undertaken by the Planning Commission. In the Planning Commission hearing, I don't want to speak for our representative, Councilman Bullock. Thank you for being our representative on the Planning Commission, but I'll just account for what's said in the report from that. The Planning Commission voted to, as Eric, Mr. Tiso attested to, the Planning Commission voted to support all of the amendments that the Planning Department recommended, but also had a number of things that they discussed as being of concern, but didn't explicitly vote to recommend a specific amendment to the bill. However, there were things like, particularly in this provision, where there was a concern, one, about the reference to the state land use article. Thank you, Ms. Floyd, for also pointing this out. The state land use article is not an appropriate point of reference in here, as was pointed out by members of the Planning Commission, and so shouldn't be in there. There was also concern from both the commissioners and also from the law department about what appears in the first reader text to be a mandate to conduct a comprehensive rezoning every single year, which is a difficult bar to reach. There was discussion about a variety of different softening, like modifications to the language, one of which was simply to add the words endeavor to at the beginning. So instead of conduct an annual rezoning, it would have said endeavor to conduct an annual rezoning. Ultimately, through a lot of back and forth, I was able to work with planning and the chair of the Planning Commission and the law department to come up with amendment number 2 in the Dorsey packet of amendments. Would change this to say, to conduct from time to time a comprehensive rezoning process in conformance with the comprehensive master plan for the city of Baltimore, which includes the land use map, without, again, also without reference to that state land use article, which is an inappropriate reference. It also clarifies in the little subsequent section using the word quadrennially instead of on a quadrennial basis, which there was some consternation over that as a turn of phrase. Any questions about this? Great. The next section, as you'll see the explanatory note on page 5, beginning on line 16 of the bill. Recent requests for a second principal structure on a residential lot have shown that the zoning code is not clear on how these are to be treated. Given increased interest by the state of Maryland in accessory dwelling units, the Department of Planning wants to add the requirement for site plan review and design review to better incorporate these options into our neighborhoods. This section is essentially kind of softly opening the door to the fairly widespread interest in the possibility of accessory dwelling units. Right now, the zoning code doesn't allow more than one principal structure for use on a property. Which means that while there are plenty of places in the city where you can have 2 apartments on one property in the same building, you can't have them in 2 buildings on the same property. Even if one is a, typical kind of house and there could be a huge backyard that could easily accommodate a small second dwelling on it, we disallow there being a second dwelling structure on the property. You can put a shed on the property, you just can't put a dwelling on the property because a shed is considered sort of an ancillary accessory use, whereas dwelling in general is a principal form of use. And so this opens the possibility of this. I think that there's still quite a bit of work to be done before we get to a point of actually having accessory dwelling units in the city, but this certainly nudges open a closed door. Are there any questions about that? Great. Page 6, the explanatory amendment. Making sure I'm keeping track here of the amendments, rather the explanatory note on page 6. Continues on with this, well, in page 6 on line 15, we have additional language pertaining to multiple structures on the principal structures on a lot. This makes a provision that in any case where somebody is seeking to have multiple principal use structures on a lot, that design review by the planning department is required in such a case. So most of page 6 and the bottom of page 5 is all the list of things that are already required to go through design review. This simply adds that to that. Amendment 5 adds further to this list of required instances for design review, new construction or substantive modifications that include a shared use path. That is a relevant amendment because one of the additional amendments here creates a definition for shared use path, which doesn't exist at present in the code. Where are we with shared use path? Well, we will get there in time. The next section of the bill, the explanatory note is found on page 7, lines 23 and 24. This amendment requires both property owners and their agents to submit applications in writing. Eric, do you want to talk about this?
Sure, this one was a holdover from last session's bill, and it merely moves the requirement for in writing from Roman numeral 2 up to paragraph 2, applying both to Roman numeral 1 and 2 equally. And I believe this is just to make sure that everybody that is going to do something is applying in writing. I believe, and the zoning board can speak to it as necessary, there have been some cases where folks have applied for something on a property that they don't own or control, and having that authority in writing is evidence that that is being done correctly.
BMZA, you want to talk about that? Or does that sum it up? All right, great. Does that make sense to folks? If you've got an owner and you've got an occupant, the occupant can't just go and apply for something to be done with somebody else, a property that they don't own. It sets a basic standard that the owner has to be included in the process of what's being allowed to be done on the property that they own. This is pretty basic stuff. Okay, the next section of the bill, let's see, it starts at the bottom of page 7, variances. Yeah, Eric, I'm going to defer to you on this one as well.
So this is also some carryover from the prior bill, talking about variances to clarify some of the language, breaking out large paragraphs into separate lines, and basically authorizing the zoning administrator or the board. And then I think there's an amendment to add or the city council, because you can grant variances as well, have to do it pursuant to the standards set forth in the subtitle. It takes the piece on signs, breaks them out into the preferred format, and clarifies that, we don't do what some jurisdictions will call a special exception where there's a variance for uses. We don't do that here. It's just Vulcan standards. And that, I think, pretty much sums it up.
Great. And as Eric noted, so at the top of page 8, in lines 5 and 6, it discusses who may grant variances, and it lists the zoning administrator or the Board of Municipal and Zoning Appeals, but it doesn't list the city council. You have all seen ordinances come before this body that grant variances. We are obviously an entity that can grant variances. It's just been omitted from this list in error. So Planning Department Amendment number 6 simply adds in the city council to that list for authorized bodies to grant variances. Similarly, Dorsey Amendment number 4 makes the same change in section E. So on page 8, you have the same error, the omission of the city council in this list where it says BMZA and it says the zoning administrator. It should have been there. In my reading of the bill, I noticed that. So you have the first error corrected by Planning Department Amendment 6, the second error corrected by Dorsey Amendment number 4. I skipped over just above this. Oh, yes, also in this section, Planning Commission and the Law Department, I think, took concern with lines 15 through 17, where it says the variance procedure provisions set forth in this subtitle shall not be construed to permit the zoning administrator or the board to authorize a use of land not otherwise permitted under the guise of a variance. Yes, the concern here was simply for concise language, clarity of language, and so trying to make this, make folks happy. I have amendment number 3 to simply simplify this to say the variance procedure provisions may not be used to authorize a use not otherwise permitted in the zoning district. This is already understood. I think in most part, you know, when you look at a table that says in a residential zone category, you can't put a power plant because it's not listed as a permissible use. You can never say, I'm applying for a variance at my house in order to allow me to have a power plant here by the process of variance. No, you can't do that. That's not why the variance process exists. The variance process exists so I can say, you know, my house is supposed to be 10 feet away from my property line, but I'd like it to be 9 feet away from my property line. That's what a variance is for, kind of a placement of use, not form of use, type of use. And so this simply says something that I think we already understand, but it makes it very clear and pointed in this section of the bill. Councilman Parker, did you have a concern?
Thank you, Mr. Chair. I'm just looking at explanatory note. I think this is one of the most substantive parts of the entire thing, so I wanted to pause here for a second. The explanatory note there, page 8, 24 to 28 in this section, points out that we're removing the unnecessary hardship, maintaining practical difficulty, and says it's conforming to case law. Would someone from BMZA or somebody else involved in kind of explain that? Just break down practically what that means for us, what this change will mean in terms of people who are applying for variances. I know I've had some of those conversations directly with you all, but as we are getting ready to vote on this, would love to have a refresher.
I'll take this one. So it doesn't make any actual practical change. The case law says that the unnecessary hardship standard applies to use variances, which is what Councilman Dorsey was just talking about in terms of, in some counties you can apply for a use that is not allowed by variance standard. In some places you can do that. In the city we do not do that. And so that unnecessary hardship standard applies to use variances, which we don't have. And so we've never used that standard. It's just cluttering up our code, and that's why it's being removed, because we don't use it.
Great, I really appreciate that, and that jives with our conversation, but wanted the refresher. Thank you. Thank you, Mr. Chair.
You're welcome. Any other issues at this point? All right, I'm gonna break here for a moment from your regularly scheduled program. I want to invite council members Ramos and Jones to come up here and present their amendment, if you would. If you could come up here, that'd be easier for me. I think better more from the or from a desk here. Council members Ramos and Jones, not members of the committee, do have an amendment here that, and I want to respect their time because we're going to be here for a little while with this bill. I want to let them present their amendment, which we will, as a committee, consider, but I want to take some time for that right now. Ramos, Jones?
I'll take it first and then defer to my colleague. Good morning, Mr. Chair, members of the committee. You'll see in your packet an amendment from the both of us. I'm sorry that I will have to leave in a little while. So if there's any further questions, I'm happy to take them by text or phone. What this basically does is currently in industrial I-1s and I-2 land or properties, the placement of large utilities like electronic or electric transponders, big facilities that we actually don't have in Baltimore City, would be a conditional use by board. What we're proposing to do just in I-1s and I-2s to make that conditional by ordinance. And that way there is a much more transparent process for if whatever company you want to talk about wants to put a utility that's fairly large in industrial land. So that residents would be able to have a hearing that's more than just a zoning hearing that have to come to the council person. Council people, do our own processes for getting input from residents and to make it more transparent. We would be open to looking at all the other zoning districts for this, but thought to narrow it for industrial. And I'll yield to my colleague if there's anything else you want to add.
Yeah, as Councilwoman Ramos said, it's just about transparency and just letting the community have a say in what's going on and create a process in which, these industrial, these terminals just aren't popping up in certain neighborhoods without the community having an actual say in what happens. So.
Yeah, so I have one. How does this constitute like solar farms? So I know in South Baltimore, we have quite a few classifications that are right next to each other. Talk to me, you mentioned utilities, but does that include solar farming? Does that include data centers? What does that include?
That's a good question. A data center isn't considered a utility, so that wouldn't be included, although I know where you're going with on that.
But they
because
use utility.
They use, so that's a good question is, if somebody's going to be putting like a large transponder because to power their business, we do have in there that it would be external utilities and internal that would have to go by ordinance. Again, happy to, modify that if needed.
And does that include new substations as well?
Yes.
Okay, thank you.
And in terms of your question regarding the solar, that's an excellent question, and we would have to dig into that. But I believe that solar would be included as a utility. Yeah.
Director Guthorn, is that correct?
So the definitions with respect to alternative energy system, commercial, and several other uses are further defined in the code.
Okay.
So when speaking about substations, these are explicit in terms of indoor and outdoor, and then utilities is a little bit more narrow in terms of, transmission lines and poles above ground.
So are they included or are they not included?
So the director actually did remind me that in a different part of that chart where there's industrial is the alternative energies, and we have not included that here.
Okay. And then for all substations that are currently being developed, how will this amendment or process impact them now?
It depends on the stage in which they're being addressed. Like, for instance, if they've already gotten permits, then they won't be, this wouldn't be retroactive.
Perfect.
But if it's new, then, that this would apply.
Okay, thank you so much, ma'am.
Yep.
And more than anything, I would just highlight, it doesn't necessarily prohibit it. It just allows community input, where if the community supports it as well, then it could get passed through zoning. But what this does, it just allows the community to have a say in what's going on in their neighborhood.
Mr. Chair, respectfully.
Mr. Schnella from the mayor's office.
Thank you, sir.
Identify yourself.
Tyler Schnella, Mayor's Office of Government Relations. I would offer to the sponsors of this amendment that our zoning review process is transparent. And it does allow for neighborhoods to have a say in what happens there. I think separately though, and I think this is just more globally around just reminding folks that this is an administration bill. And when we do have amendments to our bills, it'd be helpful for me to have awareness of these amendments prior to the hearing.
Sure.
As well as a meeting, right, to understand what this is. I'm not at this moment ready to accept this as a friendly amendment. I just want to be transparent about that. In this venue, right? I think that there's some outreach that we need to have to our partners and that we would want to do to make sure that we are not unnecessarily impacting any projects or anything like that. So just wanted to put that on the record.
Sure, and my apologies to the mayor's office.
Thank you.
Reach out to you.
I know where this is coming from. I've been involved in a lot of back and forth over where this is coming from over the last couple of months. I'm concerned actually that the way that this is drafted is too broad to address the concern without having, I actually think, grossly unintended consequences. I need to ask the planning department if you can explain all of what's included in utilities.
Sure, let me pull that definition up. So from the definitions section 1.3.14, Utilities includes natural gas lines, power lines, alternative energy systems, steam lines, telephone lines, cable television lines, fiber optic lines, and other communication lines. Talks about above ground versions of that as well, et cetera. So it's pretty broad.
Yeah, my concern here is that what we're talking about, what's in this amendment says that in the I-1, let's take a historical step back here for 1 second. Like, zoning originates kind of from one kind of concern. Industrial stuff, heavy industrial stuff should be over there, away from kind of everything else, right? We don't want people living right on top of smokestacks. That's kind of the whole origin of zoning. So there's a certain expectation that I-1, I-2, the most intensive industrial form of use that exists in many cases. Now, certainly Councilwoman Porter is very tuned to the problems of proximity of industrial use to residential uses and how we've had kind of problematic land use patterns over many generations, for sure. But there is a certain expectation that these are kind of the most far removed kind of uses from where people live. And so if there is a need to build any of the kind of things that Mr. Tiso just listed, I mean, essentially any type of utilities use on these land, on this industrial zone land, that's not something that I think I want to have come before the city council on every single occasion. I feel like the particular case of concern driving this, it kind of needed something more narrowly tailored.
I think that's why what we did with establish in the rest of the amendment that it would be indoor, again, happy to figure that out, and outdoor electric facilities, so that the utility part, we may be able to answer the question with just putting that and not necessarily conditional by board or conditional by ordinance, on utilities broadly.
Yeah, because in the conversation that we had, I think the concern has very specifically to do with overhead transmission lines.
Yeah.
And the old zoning code very directly spoke to overhead power lines. And I think what I thought we were going to get was something that spoke uniquely to overhead power lines, similar to the way that the old zoning code did. Not.
We were trying to figure that out, and we're not successful, but we could try again.
Okay. What I'd like, are there any other questions from the committee? Yes, Councilman Blanchard.
Yeah, thank you, Mr. Chair. Just a comment to make about, I think, amendments to this bill. Is a conversation I've had with the chair as well as with Mr. Tiso about the idea of having the administration bill be mostly like direct procedural improvements, things that are consistent snags in zoning and zoning appeals and whatnot, as opposed to being a lot of more substantial changes to the zoning code. Just as an example, Councilman Jones, Councilman Torrance, and I were looking at an amendment that would change OR1 to allow food processing light within OR1. And I think the three of us, not to speak for them, but I think we're all pretty interested in that. But we decided not to introduce the amendment because it's not really germane to this, and there's so much going on in this bill that I think we should limit amendments to this bill to being these types of procedural fixes and whatnot, and things that are more substantive should be their own. Like, I'm certainly to the one that me, Councilman Jones, and Councilman Torrance are looking at. I think we're interested in introducing that as a separate bill. Certainly I am. And so I think that this is probably a conversation, my sense is this is probably a conversation best had as its own separate bill as well.
Thank you, Councilman. Here's where I'd like us to go with this at this point, because I do want to keep us moving through the rest of the bill. I think, well, I'm going to use Councilman Blanchard's as an example. He came with a concern that arose from a specific case where something that seemed utterly reasonable was being stopped from happening. And much of what this bill is about is making it possible to do things that are utterly reasonable and where the zoning board or the planning department or council members find again and again and again that reasonable things are being obstructed, especially repeatedly. In the effort, again, to stick with Councilman Blanchard's example, in the effort to try to find a solution to what seemed like an unreasonable problem, we said, I guess that we need to change something in the zoning table. And then Al Berry in the back here said, no. What that person was trying to do is actually utterly reasonable and actually incredibly common. It had just been kind of poorly represented and was denied for the wrong reasons. And we're going to work this out. And the next day, it was worked out. So there was no need immediately to make a much broader change to solve a kind of a single problem. And so what I think is that the amendment here probably does something much broader than the narrow thing that is at hand that I do think is a pressing and meaningful concern. And that what I would have hoped for and what I'm still hopeful we can get to, perhaps by Monday, if we're going to vote this bill and have it on second reader on Monday, is an amendment that addresses the issue of overhead transmission lines very specifically, without the kind of potential for unintended consequences that I think that this opens the door to. Is that reasonable?
Yeah, thank you for your consideration, and I appreciate all the questions from the committee.
Okay, great.
No, that's definitely reasonable, and the reason why, just to give you further information on why it was, attempted to go this route is because there was previous language that prohibited it, which after zoning changes then made it prohibited, but made it allowable, and we was trying to fix that language, but we'll nail it more down, like your recommendation said.
All right,
Chair.
great. Thank you.
Yeah.
And let's catch up after this hearing. I want to talk about it a little bit more. Okay. Thank you. Thank you. All right,
Thank you
back
so
to our
much.
regularly scheduled program. We're going to get back to the bill. We were on page 8. Cool? We reoriented here, everybody? Let's see. What begins at the bottom of page 8 and goes on to page 9 is there for the sake of what you see on page 9, lines 12, it's just line 12, where it clarifies that either the zoning administrator or the BMZA may grant minor variances from the regulations of this code. That's pretty straightforward. Any concerns, questions about that? Great. The next section pertaining to approval standards. This is approval standards pertaining to minor variances. Am I correct? Yes. Let's read the this is the longest explanatory note. Becky, thank you for this one. You want to take it away?
Sure. So these are the approval standards for all variances.
Sorry, I'm
minor
just
and-
referring to you as Becky. For the people at home, every time I call on you, can you just
Sure,
identify yourself?
I'll state my name again. Yeah, Becky Witt on behalf of BMZA. So these approval standards under 5308 apply to both major and minor variances. The changes basically are under subsection A1. It essentially adds in this requirement that the variance has to be based on conditions peculiar to the property, and brings in a standard of practical difficulty. It's basically borrowing this from subsection B1 and 2. of the current code. And it's substituting the word peculiar for unique, which has been a touch point lately, this concept of uniqueness, that variances are for properties that the board or the zoning administrator or city council has found to be unique in some way that requires an exception from the bulk and yard regulations. So again, it just substitutes the word peculiar for unique. And then in subsection A2, it adds in kind of a new standard that talks about exceptional circumstances related to the specific structure or land involved. So that is, I think, an attempt to slightly broaden the variance standard. It's borrowed from Anne Arundel County law, and it also removes that unnecessary hardship standard that we already talked about. Those are the major changes there.
Any questions about that? Great, modest change here. Thank you. Let's see. The next bit here pertains to the time limit for utilization of a variance. Right now, if you come before the zoning board or the zoning administrator and are granted a variance and you are unable to execute the construction of your project in utilization of that variance that has been granted to you, within 1 year, you lose the variance that you spent probably months waiting for a hearing to try to get. And it's just the case that in so many cases, construction projects take longer than people thought they were going to take. And so this extends that from 1 year to 2 years as the period for which the variance stands once granted before lapsing. Any concern, question? Great. The next section confirms applicability to both a variance and a conditional use application. Does Eric or Becky want to explain that?
I can do it real quick. So essentially, there was a section put in that said that the zoning administrator and BMZA can't process variance requests or conditional use if there are outstanding fines or violations that DHCD, for example, may have put on this property. But then we get into this loop of if they're trying to get the conditional use in order to fix the violation, then they'll be stuck. So basically this would just add in and say, if you're trying to fix an outstanding notice of violation with this application, then we can allow it to move forward for both variances and for conditional uses.
I love it.
Yeah.
We're fixing practical difficulties. Yes, Eric?
That's the mechanical function. I'll give you a colorful example of why this matters. I recall a specific case years ago of a seafood restaurant that during summertime put out some picnic tables in their parking lot for outdoor dining, which was not an approved use for the property. They got a zoning violation. They filed a case for a hearing. They dragged their feet. Summer was over. They no longer needed it. They withdrew the appeal. But while they had the appeal filed, it stayed enforcement. So we don't want folks to weaponize our procedural rules in that way.
Thank you. There is a planning amendment to this page. On page 11 is where we are, in line 13. And again on line 18. The language in the existing code uses the word process, where it's really intended to say approve. It's not important that the zoning administrator process an application, do something clerical with it. It's what's prescient is whether or not they're actually approving it. And so this just fixes that incorrect use of language there. The next section, beginning at the bottom of page 11, actually does something that we discussed earlier. It adds the city council to a list where it says presently it just says the BMZA, But we add the city council to this, which is sort of already the case. It was an omission, so it's essentially correcting a typo in the existing code. No concerns there? Okay. Similar to the provision discussed a moment ago pertaining to variances, the next section, beginning at the bottom of page 12, addresses the time limit for utilization of a conditional use. A conditional use and a conditional sign approval lapses and becomes void this changes it from 1 year to 2 years. Have I captured that correctly, Eric?
Yes.
Great, thank you. Any concerns about that? No more for conditional use than for variance. Great. The next segment of the bill, beginning on page 13, line 8, we are addressing legislative authorizations. This pertains to the introductory statement of intent, Councilman Bullock's favorite thing. This is essentially a previously uncodified standard in the code. We're adding some basic standards here, and there are some amendments to it. Do you want to just talk about this just in brief?
Actually, I think this came from DLR.
DLR. Ben.
The requirement to include a statement of intent with, I would say, private interest zoning bills previously was codified in the old zoning code. It got dropped. It is still something that council members request, and it's easier for me to ask a constituent to provide it if it's codified.
Thank you, Ben. Within this are also a need for an amendment on planning. Is this correct? Yes, planning amendment number 8. On page 13, this is not only pursuant to a planning commission concern, but also law department concern. So this changes the planning amendment, the amendment number 8 recrafts number 5 here. So page 13, lines 28 through 30. It changes this to instead say that among the statement, the requirements, the contents of the statement of introductory intent, it says an affidavit executed by the applicant stating the following: I, Ryan Dorsey, solemnly affirm under the penalties of perjury that the information given in this statement of intent is true and complete to the best of, there's actually, sorry folks to have to do this, I'm gonna give you an oral amendment to the amendment here. In between the word of and knowledge needs to be the word my. We're following here? Okay, I'm gonna just, that is officially on the record now that my is being inserted into that. Yes?
It's in the copy I think late last night there was an old version that was emailed around that was replaced. So I think the word "my" is in here now.
Sorry, I have the older copy in front of me.
If I may, Chair Dorsey, I pointed this out in an email to the committee members, and DLR provided in a most recent draft.
Okay.
Just before the hearing.
Okay. Okay. Thanks, Ben. Look, there are a lot of amendments. We've been doing a lot of work on this. Ben is really cranking it out. Thank you. I should have expected nothing less. Thank you. So, an affidavit executed by the applicant stating the following, as is in the properly crafted amendment. And then it adds a number 6. Other information required to verify compliance with the standards for conditional uses, variance, and other provisions of the code. This is really the one that replaces number 5, which was considered too vague to hold up as to legal muster. Is that fair? Any other concerns about that? Questions? All right, cool. This is fun, let me tell you. This is the first ordinance this committee has heard. I feel like whoo! I don't even need another cup of coffee. I'm so jazzed. I love this stuff. Eric, I'm going to go to you for page 14.
Sure. So this has to do with notice requirements, and this is just modernizing procedures a bit, talking about how to provide notice for a variety of things. So for map or text amendments and for PUDs, plan unit developments, it requires currently publication in a newspaper of general circulation in the city. What's a newspaper anymore anyway? So that provides a bit of a procedural difficulty in complying with that. So we already require posting that's being kept, first-class mailing to anybody who appears on the tax records, and anybody that is an owner of the property within the PUD to be amended. Similar for comprehensive rezonings. For the bottom of page 14, starting in line 24, talking about exceptions. This was a case that, there were a few bills that this popped up last year where law department pointed out some inconsistencies with posting requirements. And this is where there was one, a property owner had two properties with an intervening property between them that he did not own. He was looking for a rezoning. Taken separately, the two properties would have been difficult to justify rezoning on their own when they were split by somebody else's parcel. So the applicant and attorney worked with the intervening property owner to get them on board. They signed an affidavit agreeing to join the bill, which made a more coherent node, which helps us meet the requirements and allowed us to recommend favorably. But making that recommendation in the planning commission meeting, the concern was raised, well, it wasn't on the posted notice sign. And then later on in committee hearings, we've seen cases where we have recommended adding properties to avoid spot zoning and to fix other problem while we're in there. But it was not on the council's posted notice. And in one specific case, we had the property owner here testifying in person, please add me to the bill. So we think this amendment may solve the problem where, as a working habit, the planning department sends written notice to property owners where we are intending to recommend that they be included by amendment into a bill, or if they've agreed to it, and either they appear in person or indicate their approval in writing. We hope that that will make sure that interests are protected, but not get bogged down in technicalities.
Thank you, Eric. And this really speaks not only to the section on page 14, but it really speaks to the intent of the middle of page 15 as well, where Planning Commission consideration of site-specific standards, where basically if you've already mailed a person a notice of consideration for a change at their property, or if they have actually agreed to a change, then there is not another if something changes in the course of the hearing process, there doesn't have to be a whole new notification done to that property owner. Any concerns or questions about these notice issues? Okay. In between there is a minor thing where the notice is changed from 10 to 21 days for the postings, required postings on the property, where somebody is seeking a or am I incorrect? Is that on the property?
Yes, that's for a minor variance. This is a holdover from a proposed committee amendment in last year's bill. It was noticed that the minor variance posting was still at 10 days, where the major variance that gets referred to the board was changed years ago to 21. This is aligning those two.
Right, great, thank you. No concerns there? Okay. The next section, beginning at the bottom of page 15, I feel like we're making good time here. We are halfway through the bill in 1 hour, and any amendments that we have come across along the way, so I'm feeling pretty good about this. Bottom of page 15 begins with zoning verifications. This amendment creates exceptions to the certain notice requirements if a property is added to a proposed lot amendment. This is kind of thing we just talked about. Residential conversions. Okay, we have an amendment here, but we'll first start with why this is in the first reader text here. This section much like many sections of many bills, copies a whole lot of text from the existing code in order to give a frame of reference for some little thing that is being changed. In this case, the change that is proposed in the bill is to section F on page 17, lines 4 and 5. This is a duplicative requirement. There is already an off-street parking requirement for one parking space per dwelling elsewhere in the code that is broadly applicable. This is duplicative of that, and so the planning department says, let's just get rid of the duplicative requirement here. I have other amendments to this section. But first, any question about removing that duplicative thing? Any concern about that? Great. Dorsey amendments. Dorsey amendment number 5. Removes other duplicative requirements here. So page 16, lines 14 through 23. Create constraints within which multiple dwellings can be created when converting one dwelling into multiple dwellings. These are intended to constrain the number of dwellings that can be created, particularly in general. They constrain the number of dwellings that can be created when that is already accounted for at the end of the zoning code in the bulk and yard standards. We already say, for example, in the R8 zone district, your number of dwelling units is based on the square footage of your lot size, and it says that you can have one dwelling per 750 square feet of lot size. So if I have a lot that is only 1,400 square feet, I don't have enough lot size to allow for 2 dwellings to exist on that property, let alone 3, which is actually fairly common in the R8 zone district. When we have lot size already accounting for that, we don't also need a second requirement that each unit itself be 750 square feet, to say nothing of the fact that this is the only place in the zoning code where the code oversteps its bounds into the grounds of what is already in the building code. The International Building Code, which Baltimore City and the state of Maryland and most places across the country adopt, already has standards for what constitutes a dwelling in terms of needing a kitchen, needing a bathroom, needing a place to sleep. And it says what, could be an absolute minimum size is 350 square feet. It's really difficult to fit a bathroom and a kitchen and a bedroom into just 350 square feet. But if you can do it, why are we going to tell people that they can't create something that's more workable? It's pretty common, even if you have, say, 1,500 square feet of livable space on a property that's got 1,500 square feet of lot area where you are allowed 2 units. It's pretty common to have that space allocated to where it's like, well, I can't do 750 and 750. I could do 700 and 700, or I could do, in order to account for common area in the structure, I could do 1,000 and I could do 450. But requiring me to do 750 and 750 is just like an impractical burden, again, that has no purpose except for to constrain the number of dwelling units when that is already accounted for in the bulk and yard standards based on the square footage of the lot area. Does that make sense? That's why this is duplicative and why I don't think that it should be here. It is also aligned with, I think, much the thrust of this bill, which is to alleviate barriers that we find again and again and again to very common things that people are trying to do and that already exist very commonly throughout the city and many of its neighborhoods. So it's kind of aligned with that purpose. Any questions about that? Parker.
Mr. Chair.
Mr. Chair, thank you. I know we had a conversation with this. I appreciate that. A part of the conversation I'd love for you to articulate here briefly. You pointed out the bulk and yard standards have a square footage of the lot area as a defining characteristic of how many dwelling units could be. It strikes me that the square footage of the dwelling unit itself, like the livable area, is a far better and more realistic limitation or definition of what constitutes a livable space than how big the lot happens to be. Can you offer an explanation as to why remove this versus keeping this and removing that kind of fairly arbitrary thing that's about the size of the lot rather than the actual size of the building unit? Just if you name that for us.
Great question. Thank you. It seems to me that because this is the outlier as a different way of doing what's done in every other circumstance where you're controlling for the number of dwellings that are allowable, like when you're building ground up for an apartment building, brand new construction. Every other case is controlled by lot area today or by floor area ratio. That is the convention that we have adopted in all other cases. This is the outlier. I believe absolutely what you are saying, that livable square footage in the structure is a much better determinant of whether or not the number of dwellings is reasonable. I think lot area is a stupid standard. It just happens to be the convention that's been in place for the last 100 years. And changing that is a fight I'm willing to have outside of trying to correct this one outlier of redundancy. Is that fair? Thank you, Mr. Chair. Thanks. Ben, did you have something?
Yes, Mr. Chair. I made an error in the way that I drafted this amendment, not understanding your original intent. It currently says strike in their entireties lines 14 through 23. It should instead say insert a bracket before the start and at the end of each of the lines 14 through 23 respectively, because you're removing content from the existing code rather than simply striking it from the bill. So that's my error. I'll need to provide an updated draft of that, which you may need to introduce as a floor amendment on second reader rather than today, as there are certain amendment notice requirements to the committee.
Thank you. Did everybody hear what Ben said? I'm going to ask you to get closer to the mic in the future, or speak up. You can be loud. It's fun. Essentially, the amendment as crafted strikes language from the bill, which was only there for reference, as opposed to striking that actual language from the existing code. So he's going to have to redraft amendment number 5 to that effect. I'm actually perfectly okay with oral amendments and oral changes to amendments, especially when I expect that my colleagues here are all smart enough to understand these things. So when it comes to it, I may just make that change orally and ask you to just entrust that you're going to craft it appropriately, or we can do it as a second reader amendment. Which would you prefer, Ben?
As I'm not a council member, I cannot enforce the rules of the city council.
Can you have a preference as a practitioner?
I defer to the council members present.
Okay. All right, great. We're going to move on.
Okay, Councilman Dorsey, if I may, I confirmed some of the, in the zoning code, any amendments that would not require new notice or a second hearing need to be both proposed in and approved by the committee. So I'm just placing that on the record for whatever that might mean for how you want to move forward here.
Proposed and approved by the committee?
Yep.
Thank you. I'll come back to it. Okay. Okay, any other questions or concerns about that? We're gonna figure out how to address that before the end of this.
So we're redrafting number 5?
We're gonna have amendment number 5 redrafted.
Mr. Chair, I imagine the committee could also move to waive that particular rule.
It's, that's not in the council rules, that's in the code?
No, sorry, Mr. Chair, what I'm saying is if the intention is to correct the amendment, I believe the committee could move to waive, and I'm gonna, bear with me one moment here. Council Rule 11-7 that requires distribution of amendments to committee members a certain period before each.
This is not the council rule matter. What Jeff is bringing up is a codified notice requirement.
Director. Director, if you could speak in the mic again, I'm sorry, I didn't hear you.
Sorry, I'll speak up. What I was saying may be moot given that the law department is talking about a certain notice and posting requirement prior to committee hearings, and I was talking about the procedure for actual amendments themselves before the committee.
Jeff?
Yeah, I think that's right. And you could allow the oral change to the amendment by waiving the council rule.
Yeah, so the concern is, given the notice requirements, we can't simply introduce new amendments on second reader. Anything, because of the notice requirements pertaining to zoning, any amendments, I actually meant to cover this at the very beginning of the hearing, so apologize. Any amendments that are going to be voted by the council have to be voted by the committee pertaining to zoning laws, or else a whole new notice requirement applies for newspaper and such.
That's correct. And for the record, it's Article 32, Section 5, 507C. But as long as the committee knows what amendments they're all voting on, that should take care of the proposed and approved requirement in that section.
Mr. Chair?
Yes.
Thank you, sir. Given the clarifications provided here, are you making a motion, or are you looking for a motion to waive that rule so we can move forward on the amendments as you have explained it, or not?
That rule doesn't matter, that one does. And that one, we can't waive the rule that actually matters.
Understood.
Yeah, so I'm gonna get to it. Thank you. I wanna keep moving here. Page 17, lines 11 through 20. There's a planning amendment. Wait, did I miss one? I missed an amendment.
No, you're right, I can address that one.
I missed amendment number 9 from the planning department on page 16. No, I didn't. We just, did we?
That corrects the explanatory note text.
Oh,
That's
right,
what
it's
our
just an
amendment on-
explanatory note correction, okay.
Our-
Amendment number 10 from the planning department is page 17, striking this whole section of the bill from lines 11 through 20. Planning?
Yeah, this came about as my poor attempt to convey to DLR what needed to be drafted. I didn't need a whole new table created, just tweaks to the existing table 10401, which are included in the bill, so this is extraneous and can come out, so my bad.
Great, so planning is asking you to get rid of something that planning should never have asked for in the first place. Great. No concerns there, I take it? Great. Special purpose districts, transit-oriented development districts, parking requirements. This is about, instead of saying where feasible ingress, it just says no. Ingress to and egress from parking must be from side streets or alleys. I love it. We don't want ingress happening across the sidewalk where we expect people to walk. I mean, that's the intent here. We don't want it on the main street. If you can get to it from a side street or if we can get to an alley, that's better for everybody. It's better for walkability, especially in transit-oriented areas. Any concerns about that? Great. Page 18. Councilman Blanchard has just stepped out. I will go over his amendment pertaining to the first part of page 18 here. Blanchard amendment number 1. Page 18, lines 3 through 11 are put forth by the planning department to scale back something that was very, very permissive that was created during COVID specifically to respond to people wanting to do things outdoors collectively, and made it very easy to allow for dining on the rooftop of neighborhood commercial businesses or dining on a deck that might be in the rear but elevated off of the ground. These are, was that? Okay. These are conditions where it could these are neighborhood commercial establishments, so this is almost certainly immediately abutting a residential property. And so if you're on a deck that is elevated above the ground floor, you have visibility maybe into somebody else's backyard next door, or visibility into their kitchen window or something like that. It's sort of it really blurs the line between that neighborhood commercial use, which is sort of low intensity, and the residential use that's immediately adjacent to it. And so this scales it back to a more reasonable set of permissions on that outdoor dining where it can happen. But Councilman Blanchard has an amendment for this as well pertaining to line number 9.
Thank you, Mr. Chair. So, Councilman Park and I have had a very robust deliberation over outdoor seating over the last couple of days. Also had a good opportunity to speak with Mr. Tiso about this last week. So there's obviously a balance when it comes to outdoor seating between supporting our businesses, promoting vibrant commercial corridors, vibrant public space, and having the sorts of uses and whatnot with privacy or noise or whatever that can conflict with what you would want in a residential area. And so this was expanded, the uses in neighborhood commercial establishments for where you could put outdoor seating to include rooftops and back rear yards during COVID. And so I think the original intent of this portion of the bill was to revert back to what we had beforehand. My original thought was, hey, being very pro outdoor dining and on principle, my thought was like, hey, let's keep these. And I asked, was this something that we'd been getting feedback and a lot of complaints about, and at least from Mr. Tiso's perspective, it was more of just the process hadn't been kind of thoroughly followed for the change because it was COVID and post-COVID and whatnot. And so it's like, hey, well, let's keep it as is. Councilman Parker brought up the concerns about rooftop and elevated seating with both how noise carries, as well as particularly when you're adjacent to someone's house and you're on a roof for a restaurant or something, that privacy concerns, all these types of things. So the compromise was to just allow this in rear areas for neighborhood commercial. So that is currently allowed. It was not allowed pre-COVID. This is the one part of the change that would be allowed. I know there's a bit of sort of tennis back and forth of when it's been allowed and not allowed, but do any council members have questions about that?
Great.
Thank you, Mr. Chair.
Thank you, Councilman. So planning was looking to revert all of these things, lines 3, 4, and 5, or items 3, 4, and 5, lines 9, 10, 11, and the Blanchard Amendment leaves first reader as is on lines 10 and 11, but keeps in rear yard dining. Going to go to Parker next, pertaining to the next section on outdoor dining, starting from line 15 and on. Parker Amendment, you want to talk about that?
Thank you, Mr. Chair. Thank you, everybody. And thanks to Becky and Eric and Chris and Zach and Josh, everybody who's been part of the conversations about it. The amendment looks large. Fundamentally, though, the only action that's being taken that's different from what the bill itself has proposed is outdoor dining 2, beginning with right in the middle of that page where the amendment's printed, outdoor dining on the property for which the permit is approved, etc. That's the change. The goal here is in C1, C1E, C1VC, and C2 zoning districts, which in some ways function similar to neighborhood commercial in that these properties of these zonings are often deeply integrated in kind of residential Main Street style areas where residential uses and commercial uses are mixed together in a wonderful and really important way. It says that outdoor dining inside and rear yards will be conditional if and when those yards where the proposed use is, where the proposed outdoor dining is taking place, immediately abuts a residential property. And there's no alley in between, no alley of greater than 20, no alley of greater 20 feet or greater separating that proposed area of use, that rear yard or side yard use, and the residential property. So essentially this, anytime you're proposing a rear or a side yard outdoor dining situation where there is no alley of greater than 20 feet between that yard and someone's residential property, it will trigger a conditional use hearing in those neighborhood, in the C1, C1E, C1VC, and C2 zones. So an opportunity, because that's the situation in which it is most likely that proposed use will have adverse and negative effects on the neighbors who are immediately adjacent to that area. There's already a setback requirement later in this section of the code that says in precisely these circumstances where there's no alley and the property, the yard for dining is immediately adjacent to residential property, that there has to be a setback. So this is consistent with that setback requirement and also saying in those same circumstances, a conditional use hearing is necessary simply to make sure that we are weighing the potential adverse impacts and that this use, in fact, will be in harmony with this mixed residential commercial area.
Thank you, Councilman Parker. We've been joined by the Council President. Good afternoon, Mr. Council President. How are you doing today? Doing well, thanks. Great. Any concerns or questions about Parker's amendment?
I was just wondering if he had a sample idea of where this would come from.
The Vice Chair asked if you had a sample or kind of example of where something might be an issue.
Yeah. Thank you, Madam Vice Chair. Imagine, if you will, a property that carries a C1 zoning, so like a neighborhood commercial establishment, C1 zoning, and it has a rear yard on the property. There's no alley behind it, and immediately behind that that C1 property, let's say it's a restaurant, right? A C1 property, it has a rear yard. They'd like to do some outdoor seating in the back. There's no alley behind it of greater than 20 feet. And so kind of immediately where the yard ends, there's a fence and there's somebody's backyard or the back wall of their house, depending on the lot coverage. And so this is saying that in that situation, one, the code already requires there to be a setback. That you can't be right up against the fence line, you have to give a little bit of space. But also that use as well would require a conditional use hearing where those property owners and the owner of the commercial space could come out, make the case, say, this is why this is necessary, this is why it will or won't have a negative or at least a disallowable impact on the community. And so we want to make sure that there's that opportunity for review when things are when the use is so tight up against somebody's living space.
Thank you. That gives a good visual for the general public that live in certain areas that are not in the areas that you and the 11th District really have problems with.
Thank you, Madam.
Great. Thank you. We already discussed generally the interest, the grown interest over time for multiple principal structures on a lot. Page 19 pertains further to this. Is there anything additional from planning pertaining to that?
For page 19, this is text borrowed from the prior edition of the zoning code where it required, at the time, planning commission review where there's more than one principal structure on a residential lot. And the reason why planning commission was the referred thing is because we didn't have formal site plan review and design review at the time. And so our amendment, I believe 11, swaps out planning commission for site plan review and design review. And this is just the first phase to better allow for ADUs. We're still going to need to do some clarifications in bulk standards, but we need a bit more time to make those changes.
Great. Incremental progress. I love it. Any questions about that? Okay. Oh boy, split zone property, off-street parking. Eric. Page 20, bottom of page 20.
Yep, most of page 20 is just breaking out a block of text into subheadings. And this is where in most cases, table 10, 406, I believe it is, that has the required parking spaces, just generally requires one parking space per dwelling unit. However, there are some limited exceptions, such as in the C1 zone. And we actually had a specific property that was split zoned, and the example that's included in the bill is that specific thing, where it was split zone C1 and R8. So the project team said, well, how do we calculate parking?
Is this on Thames Street and Ann Street? I looked at that property in the code map this morning by chance. I had no idea.
So they said, okay, well, 40% of the lot or so is in a C1 zone that doesn't require parking. It's ambiguous. How do we address it? So this is adding more or less a pro rata share in those limited examples where this may come up to make it more clear how to do that calculation. There you go.
I was shocked to see a split zone property in the code and to plunk down on that randomly in the code map this morning when I was looking over some
we try
things.
to avoid split zone cases where we can, but in this case, it was property assembly that just happened to lap over the zoning line, and there it is.
Cool. Thank you. Any concerns about that? Questions? Make sense? Okay. Mr. President, do you want to say anything here?
No, I'm good. No, thank you, Mr. Chair, for conducting this hearing. It's good to see all the colleagues here. Appreciate it.
Thank you. So there was an amendment for that one, planning amendment number 11, changes the, oh no, not for that one. That was the previous one. Sorry, my bad. Okay, we're on page 21. Dealing with non-conformities. Hold on, I'm gonna make sure I have my, okay, Blanchard, I'm gonna ask Blanchard to talk about non-conformities in a minute. Oh, here we are, yeah, we are at this point, great. I was, my reading comprehension wasn't great there for a second. This section in the bill, sorry, so many different amendments in front of me. I want to make sure. All right. Okay. Page 21, Title 18, nonconforming structures. This amendment clarifies how nonconforming structures may be modified to match current practice and necessity as it relates to how variances and exceptions are approved. First, I'm going to go to BMZA, and then we're going to go to Councilman Blanchard.
So for this section, Becky Witt on behalf of BMZA, this subsection A, the proposed subsection A scope, was included pre-transform to explicitly give the board the ability to grant expansions of non-conforming structures under the variance standard. This was removed under transform, whether on purpose or by accident or whatever. So basically now it just says, what it currently says under subsection B, a non-conforming structure may not be expanded if the expansion would create a new non-conformity or increase the degree of any non-conformity. This has become a sticking point for people. And when discussing with the planning department, they were saying, well, the ability to grant variances here is implied. I disagree with that. So we're putting it back in and making it explicit that you can grant a variance, obviously under the variance approval standards, to a non-conforming structure, which was previously there. Hope that makes sense.
Any questions, concerns about that? Okay, this section is just about where we have, what's that? Yep, Blanchard?
Thank you, Mr. Chair. I'm actually really excited about this amendment here. I think it does something that's pretty important and helpful for the city. And it's something that Director Witt had brought up to me first last summer, flagged this as a concern. And so basically what you're looking at, this is my Blanchard Amendment number 2. So it's 18206 as well as 18412. There's changes made to both of them. The changes in 206, so currently, if you have a legally, if you've got a multifamily property that has been legally converted, it has to go through the zoning appeals board. But all they're doing is looking up in the zoning record, which is exactly what the zoning administrator can do. And so it takes several months out of the process for these properties to get their use and occupancy. So this is just expediting the process of rehabbing vacant homes effectively for things that have been legally converted in the past. And it's just saying that it's just a lookup in the zoning record. It is not something that needs to be done by the zoning appeals board and can be done by the zoning administrator, saving several months for the owner who is rehabbing the property. So I think that's in our efforts to fight the vacant housing crisis, doing small changes like this can add up over time and are meaningful. And I believe, and Mr. Tisa, correct me if I'm wrong, I believe this was originally planned on being in the original version of the bill and just hadn't made it on. Is that correct?
Yeah, with apologies, you did flag this concern for us and it got lost in the sauce and didn't make it to our proposed amendments list, but thank you for working with me on adding it back in.
Yep, yeah, and happy to help on this specifically. And a pretty similar situation with 18412, so that's the second part of Blanchard Amendment number 2. So currently, if a property has been converted legally from single family to more than 4 multifamily units in the past, and then is unoccupied for 12 months or more, it automatically reduces the number of units that are allowed by 1. So to give an example, so let's say you have a property that was, and I have a couple of these in my district that I've seen this with. Let's say you have a home that was built as a single family home and was legally converted to
say 4 units in the past, and then it becomes unoccupied for 12 months or more. Typically these, or a lot of times these become our blighted VBN notice cited properties. It then loses the number of units it can have use and occupancy for. So it would go, in this case, from 4 to 3, even though the house is physically built out for 4 units. It was legally converted and built out for 4 units and used as 4 units in the past. And then so you have someone, and we've seen multiple examples of this, where a rehabber comes, buys a blighted property, wants to fix it up, is expecting to be able to, in this case, say, provide 4 units of housing, but it turns out because of this specific stipulation, they now can only do 3 units. It doesn't matter that the house is built out and had been legally permitted for 4 units in the past. So we see situations, and Director Witt had brought up a couple examples of someone comes in and buys the property, they try to get use and occupancy, they can't get it for the number of units they expected, so the math doesn't work out, so they wait, they try their different avenues, they can't get it fixed, they go and they put it up for sale, someone else comes and buys it, and they go back, so they've seen the same property at the Zoning Appeals Board multiple times because of this specific stipulation. So I think this is a great opportunity to allow properties to be rehabbed and reoccupied for the use that they were already being used for before they became vacant. And I appreciate all the work that Director Witt and Ms. Tiso had done on this. So thank you, Mr. Chair.
Thank you. Any questions, concerns? Yes, Councilman Bullock.
Thank you, Mr. Chair, and thank you, Councilman Blanchard. Just want to say it's a very common sense and a well-heeled approach. So again, thank you for doing so, because again, it'll take a lot of the burden off of folks who are trying to renovate these properties, or at least put them in active use. So glad to see it.
Yeah, great amendment. Thank you. Okay, non-conforming structures. We got that covered here. We're on to tables, everybody's favorite part. The table here at the bottom of page 21 pertains to outdoor dining matters. Is there, in the amendments that we have pertaining to outdoor dining, are there any concerns? I'm going to check with Ben Guthorn here real quick. Anything that in these tables? Okay. So that's just about the outdoor dining stuff that we've already discussed. Okay, that's you. Have fun. Hi, Jackson. Page 22. There's also an amendment just to the explanatory note here. Go ahead, Eric.
Okay, for table 10-401, there are actually 3 different things that are happening here, and then there's, that the explanatory note covers those 3 things. I think we tweaked that a little bit. In the top group of minimum lot area, basically lines 4 through 8, all the way at the right edge under C4, there was a mistake there where 120 square feet per unit was repeated across, but that use is not allowed in C4, so it should be none instead, so that corrects that mistake. And then in lines 15, 16, 17, well, actually, I should say also in 10 through 13, that title of maximum lot area, I believe, was a mistake. I think it was actually intended to refer to the maximum gross floor area by the use itself. This came to us with a property that was looking, it was a C1 property, wanted to buy an adjacent parking lot, which would, of course, would expand its lot area, even though the building wasn't changing. And so the question was, wait a minute, do we go over the 10,000 square feet of the lot? Is that a problem? And that's where it kind of flagged that, wait a minute, our concern here was not over the size of the property, it was over the size of the building, because C1s are walk-to neighborhoods, and we didn't want folks to assemble a row of them and put in, a massive use on that assembled property. So we think this correction will better capture that. At the bottom of that table, lines 20 through 22, this was another concern brought by an applicant that had a through lot. So this was a narrow lot that stretched all the way from one street through the block to the other street, but adjacent properties on the backyard street side were fronting on that street. So there was an inconsistency that came up of, okay, how do we apply the bulk standards? Because our lot goes all the way through. So on that, what would be their rear street, they would require a setback because it's their rear yard. Meanwhile, the adjacent properties left and right on that side, it's their front yard, and they have to build to the street. And that incompatibility doesn't make sense. So by inserting the a street or to add to the existing requirement for an alley fixes that inconsistency. So that's three different things that table does.
Great, thank you. Any questions? I'm going to go back 1 second because I forgot about my own amendment on the previous page, on page 21, toward the top of the page, above nonconformity. So sequentially in the code, this is in Title 16 before we get to to Title 18. Dorsey Amendment number 6. This addresses the practical concern that has come up again and again and again, and where I have never seen it denied, where in the course of approving conditional use conversions, it's almost always the case that it requires a variance for off-street parking, that they're turning a row home into 3 dwelling units, and they can't have the row home and 3 parking spaces in the backyard of the property, and we have to grant the variance over and over and over again. And this is, again, a thing where we should be correcting systemic problems, making basic changes, and one that I said, especially, I think, to Councilman Blanchard's point before, make minor constructive changes toward us addressing our housing crisis, making it a little easier to build housing. And so Dorsey Amendment number 6 says that when you're creating housing, the first 3 dwellings or up to 3 dwellings requires no off-street parking requirement. That also means that if I'm building 10 dwellings, I only need 7 off-street parking requirements. If I'm only building 3, I need none. If I'm building 1, I need none. I think that's pretty straightforward. Much of the rest of this text is just kind of the restructuring of this section of the code pertaining to exemptions in general. There's already a list there. This is just adding one to it, but restructuring the list. Questions? Councilman Porter.
Thank you, Mr. Chair. What happens with areas of the city that are that require that density in the not require, but they have very strict parking restrictions already now, and there's already kind of not enough parking? How does this amendment work with those existing neighborhoods? So, for example, in Ridgely's Delight, there's not enough parking. There's much building that's happening, and so how do we reconcile that?
Good question. I mean, I think philosophically it's a question of, is the parking the thing that should drive, is the convenience of where people can park cars, and specifically a convenience being forced by the government, is that convenience a greater priority than whether or not the housing can exist, period? Right? If we make the creation of housing contingent on whether or not there is a place for somebody to store their personal property outdoors in public space, or rather, elsewhere on private property, this hinders the creation of housing. There is almost none of the city as it exists today could have been built if the law that we have today existed when the city was being built. We just, we couldn't look like anything but Jacksonville, basically. We could only be a suburb.
My only concern is that with transit needs kind of flowing throughout the city and the lack thereof. I wonder if there can be some sort of consideration for residentially dense neighborhoods so that they are able to at least come to this committee and plead their case or have some sort of leeway there. I know a few of my communities are already in that space now, and they do have property that's being developed. So I just want to, take that into consideration as we kind of talk through this amendment.
Appreciate it. Yeah, we have, for the last decade, seen 8 conditional use conversions from single family to multifamily in the whole city every year. So it's an incredibly slow or low rate of these actually occurring. And so they still have to come before the council as is. And I've never seen one denied on the basis of the parking requirements.
And so just for clarification, this is for conversion. This is not for apartments that are being built. Is that
This
correct?
would also apply to apartments being built, but in those areas when new construction is happening, basically the, if you're talking about one dwelling being created, this is because this is only for, again, this is only for 1, 2, or 3 dwellings. So if I was building 10 apartments, I'd still have to build 7 off-street parking spaces. And in most cases, that's probably what the market demands anyway. And in such cases where I'm a builder, a developer, and I'm cobbling together funding sources from equity partners, from bank lenders, from tax credits and such like that, basically nobody's going to give me the money anyway to build my project if my lender doesn't think that I'm building adequate off-street parking. And so the market has continuously controlled for this in the first place.
Okay.
And further, if I'm building 20 units, I don't have to build any off-street parking because we already have an exemption for that. And most of those things where people are building 10 or 15 or 20 or 25 units aren't, they're also not in residential zone areas where people are, like row homes, right? Where parking is often the most constrained.
Yep.
And that's the places where it would apply if a person was having a waiver of just one dwelling unit or one parking.
Yeah, I just want to, I fully understand the intent. I just want us to really think through operationally if, what happens after that or what happens in place of that for the committee. So thank you so much, Mr.
Thank
Chair.
you. Blanchard?
Thank you, Mr. Chair. To Councilwoman Porter's point, maybe 2 things just to observe here. And speaking as someone who has plenty of, very dense, a lot of row home neighborhoods in the district. But one, so a new row house dwelling that is a single family in most situations, certainly in, I think how Ridgely's is laid out, actually already has an exemption from the parking requirement. If it were, so if it were for 1 unit, let's say you had a vacant lot and then it would be put there.
No, these are existing apartment buildings.
Right, that would be, what I'm talking about I'm saying for just in general, like if you had an infill for a new build, in most situations, it would have an exemption for it. And so this is kind of covering that for 3 units or less.
So it's not necessarily.
Hold on, can we have either microphone or a side,
yeah.
conversation, or it can be in the
Sure, yeah. And then sorry, Mr. Chair. And then the second thing is, I just think it's worth noting that there's a bigger conversation around how do we manage parking in the city, and whether that's done through the zoning code or other ways. And it's a really important conversation to have. This specifically, I think, going back to Chairman Dorsey's point, is about because when someone puts in you know how this works, right? They have the conditional use request for the conversion, but then the variance is part of the conditional use, and those are different. The standard for conditional use is lower than a variance, and it's problematic from like an actual, how these things are factored out on the council level was, I think, what my understanding of what originally drove this to be put into this bill.
Thank you. Parker?
Thank you, Mr. Chairperson. So just, I heard my colleague, Councilperson Porter, ask a specific question. I'm just going to follow up because we don't have the whole code in front of us. We just have the bill. This 3-unit no parking requirement, no off-street parking requirement is not just for conversions, right?
It's not just for conversions.
It's for everything.
That's correct.
I would suggest that is a significant enough change to how our communities operate that it's worthy of a full and robust conversation, especially in as much as this is an amendment that the general public, communities, property owners, and others didn't have a chance to see a review or know what was going to be before us today. And so I imagine there'd be a number of members in all of our districts, residents in all of our districts who would want to weigh in and have a robust conversation about what the impacts would be on their community. In as much as this is not something they'd seen, that conversation hasn't happened here, those voices aren't present here. I would suggest that perhaps it is too big of a thing to incorporate in this way without the chance to have that conversation.
Well noted. Gray?
Thanks. Yes, and I would just like to follow up on Councilperson Porter and Parker's concerns, and I echo the same. There is a particular development that could be happening in my district where it is abutted to a very major thoroughway, and it just concerns me that if we're going to build more than, I guess in this instance, if it's 6 or 7 units, single-family units, they could only have to then thereby build like three dedicated parking areas, but there isn't any dedicated parking outside of that. And with that, I just know that this raises issues and concerns, so I just echo the sentiments of my fellow colleagues as well.
Thank you. I'll just say again, this is intended to address essentially the only case where it's an issue over and over and over again, where I've never once seen it denied, where people come to us looking for a variance for 3 dwelling units. We're doing other things throughout this bill to make it easier for people to do these things that are practical barriers to people doing something that's incredibly common. As was brought up, there's already an exemption for row homes. So if you're building 1 row home or if you're building 10 row homes, it's still exempt from the row home requirement by the row home requirement. So you have to build 0 off-street parking spaces if you're building a row of 10 row homes. If you're building 20 units, you have to build 0 off-street parking spaces, but we expect that development will lead to some number of off-street parking spaces being created in most circumstances. And so the only real gap is in these things in between, which are like the most practical kind of infill development that we need so desperately, and where off-street parking is, just such a known, I want to say, leveraged obstacle by people that simply don't want housing to exist in their neighborhood. I would say also it's the case that most properties where people are seeking variances don't actually have anything particularly unique about them. Most row homes look just like all other row homes in their communities. And so every time we have granted a variance that says there's something characteristic about the lot that makes it impossible for them to create the off-street parking, there's nothing unique about that particular lot. We're just granting the variances because we're in the mode of granting the variances. And every single time we've ever done that, or had one brought to us, we've granted it. And these are so incredibly common that I don't think that this is just I don't think that this is something that's like a big change. I think that this is absolutely us fixing a very, very common problem that's extremely minor in its actual impact.
Mr. Chair?
That's my case.
Mr. Chair?
Yes,
Would you
Porter.
Thank you, sir. Would you consider a friendly amendment that this would only constitute to residential conversions? Instead of yeah.
Let me think about it.
Okay.
Thank you.
Which amendment are we on?
Yeah. Or Dorsey 6.
Dorsey 6.
I want to get through the rest of the bill, so we'll come back to this as we come back to amendments. We are on page You got it. We're going to move on from that for right now. We're on page 23. Top of page 23. So many amendments, it's really hard to keep track of the different papers here. There is an error in the explanatory note here. The correction is amendment number 13, and it explains why this table 11301, is here. And so I'll just read it as if I'm reading the corrected explanatory note with the amendment. This amendment corrects for an error in the prior zoning code, now making the use entertainment, live, accessory to restaurant, tavern, art studio, or art gallery permitted in the IMU1 zoning district when the former singular, am I reading this right? Yeah, when the former singular, basically IMU at some point in 2019 was split into IMU 1 and IMU 2. And the P for permitted for live entertainment was omitted by accident from IMU 1. It's just putting it in there. It's correcting that error from Transform. Any concerns, questions? Great. Rest of page 23 is all the OR district. Do you want to explain this, Eric?
Yes, so if we're looking at page 24 in line 14, this is a little bit of shorthanding that was attempted here and it was done incorrectly. So when we listed neighborhood commercial establishment here for the OR districts, what we meant was to include the 7 uses that are incorporated with that, but the practical problem there is that in order to be a neighborhood commercial establishment, you have to be an existing building that meets certain requirements. It has to be that it had a former commercial use and the structure is of a certain type, and that's not what we meant. And this came up when somebody requested a specific use, but then it was a new construction, so it didn't apply to them. So what we do is we're striking neighborhood commercial establishment, and then by amendment adding in those uses that were not already in the use table. So office, for example, was already in the use table, but art gallery, art studio, personal services establishment, restaurant, retail goods establishment with no alcoholic beverage sales, and then our amendment to add daycare center finishes that list of 7 uses from the NCE in the table, but in this case, it allows for new construction.
And then
Thank you, Eric. Any questions about that?
trying to find
The amendment, again, was only to the explanatory note to make it make sense.
And this was page 23, right, Mr. Chair?
Page 23.
Okay.
Yeah. Page 24, did we cover this, the daycare? We just covered it. Okay, great.
Well, while we're on 24, Mr. Chair, can I flag that, and I know you and I discussed it earlier, in the bill, there's nothing in the table for art studio.
Oh, yeah, I was wondering about this. Thank you. Line 9 on page 24 has nothing in the district column.
Oh, yeah.
That should be a P, right?
Yeah, it should be mirror the others, CB, comma, P with footnote 1.
So
It should look like CB, comma, P,
Superscript 1. To match
right?
the other ones, yes. Because that's allowing those uses where, and if you read footnote 1 in lines 27, 28, that's for structures with 50 units or more.
Okay, committee members, if when we come to voting these amendments today, I offer an oral amendment to address that, are we understood about that? This is, so on page 24, in line 9, in the second column of the table, insert CB, comma, P, superscript 1. Cool? And we're going to call that planning 15. Page 24, line 9, CB, comma, P, 1. Okay. Thank you, Tyler. Appreciate you catching that there. Transit-oriented development, animal clinics are listed as P, but it had been erroneously omitted from TOD 2 while being in there for 1, 3, and 4. This fixes that. Take it there, no concerns there. The last 3 pages of the bill are all me, sort of. When the council passed the Harford Road overlay ordinance at the end of last term, there was an error in the third reader copy where the amendments that we passed on second reader didn't, the text amendments were incorporated into the third reader redraft, but the table amendments did not make it into the third reader redraft. So what the council actually passed, or intended to have passed, didn't actually make it onto the mayor's desk, and this just takes that table amendment that we actually passed on second reader and believed we had passed on third reader and takes care of it. That's it. That's the bill. Jeff, we have a couple people who are time constrained. I had really hoped we could get it through all that in 1 hour and 50 minutes, but we got through it in 1 hour and 62 minutes. Do I have to go to public testimony before voting any of this? Yes.
Mr. Chair.
Yeah.
Point of order.
Yes, sir.
I think you might have missed the point about the fence height, the amendment about fence height from planning, changing from 3.5 feet to 4 feet.
Did we miss that?
And that amendment came from a public comment that we got that common fencing stock is sold in 4 and 6 feet, where our code since 1971 has required 3.5 feet. So we figured it's easier just to give them 6 inches instead of trimming typically available materials.
Okay. Great. Do we have a list for public testimony here? I don't want to hold up John, but I want to get this done.
Have 2 people, they have that pen, so they can check the box with testifying, but, so in this case, you may want to just ask.
Okay, I have Al Berry. You haven't actually checked the box for wanting to testify. Do you want to testify, Al? Okay. Ms. Floyd? You good? Would you like to testify? Oh, we have your letter. Do you want to? Okay, great. Come on up. Do we have anybody?
Okay, thank you. All right, so, yeah, you do have my 3 pages. I'm going to limit my, four items. I'm going to, oh, I'm sorry, Joan Floyd. And this review that I sent to you, and I apologize because I had to do extra work for it, so I couldn't get it into you by that, 10 o'clock deadline. But this is the work. This is very similar to the work that I've done professionally for almost 20 years. Understanding code, understanding what, how it's going to be interpreted, perhaps misinterpreted, and sometimes finding the things that other people don't find, and from a perspective generally of the residential community. So I'm going to skip ahead to my page 3, the last item, and I really have to take exception to the idea that it was an error to leave the P out of the IMU for live entertainment accessory, because if you look at the way that the IMU was split, this is on purpose, not an error. And I included the definitions for your reference, and I've included the fact that the IMU1 is generally for industrial buildings that are adjacent to existing residential buildings, typically row houses. And so that is basically why the P was not in there, because you're cheek by jowl with row houses, other residential properties. And then actually, the IMU1 district also allows residential within it. So this is the rationale for not having, accessory, a lot of entertainment for bars and restaurants in that IMU1. Okay, next thing, to just point out something, I think I heard, what I think I heard today was that maybe the yearly comprehensive rezoning is not on the table anymore. I'm not quite sure. But let me just bring your attention to the word conduct, I think is a problem in this. If you're saying you're going to have
I'll speak to this again to
Sure.
remind you. The amendment that we have says from time to time.
Okay, yeah, okay, thank you. So then I will say the word conduct would be still a problem, because it looks like you're saying that the Planning Commission is going to conduct comprehensive rezoning, and it's the City Council that actually, does comprehensive rezoning. So the Planning Commission could maybe, initiate it or suggest it or whatever, but conduct it seems a little bit tricky there. So I'm going to move on to the third item I'm going to talk about, which is the issue. I heard you all talk about that business of the applications in writing. I don't think the amendment achieves what you think it's going to achieve. I think it perhaps just the opposite. I'm talking about applications, page 7, lines 16 to 18. I think the amendment actually achieves something worse rather than something better, because I think, and I've given you an example of, and I've asked the question, if you take this out, how does the zoning board know that the owner has actually expressly authorized? That's the question. If the application is coming from somebody other than the owner, how are you going to know? Right now it says the authorization is in writing. You take that out, and I've just given you a couple sentences there, but I do think it's making it worse rather than making it better. And it's been a frustration for me. I've seen this come up in several cases, and it's been a frustration for me because it's a simple fix. You do what the liquor board does. You put it on the application. You see, if you're not the owner, give us the owner's signature. Simple, but for some reason we don't do it. And then, now for the big one.
Okay, and then I'm going to cut you off after this one.
I'm sorry, I didn't.
You have one more thing?
I have a big one. This is the big one. This is the most, I think, substantive thing perhaps in the entire bill, and I think it's being missed,
Go for it.
which is the fact that you're opening up variances to almost.
Can you step back just like
Sure,
an
I'm
inch,
never
please?
good with these things. I
Yeah.
apologize. You're opening up variances to almost every part of this code, including the special purpose districts regulations. Because you take out certain language that says what it's limited to. When you do that, you open it up to the entire code. So right now, you've said it doesn't apply to 3 types of signage regulations. And you've said, the draft said you don't apply it to uses. If you have to list everything that it's not going to apply to, or else you have to say what it does apply to. But the explanatory note is just 100% wrong here. They're citing the wrong code sections, and Baltimore City is different from all the other jurisdictions in this regard. So if you take out the language that limits like the bulk regulations language, you are literally opening it up to just about everything. And I think that's something that hasn't been vetted by anybody, frankly, at this point.
Thank you. Thank you, Ms. Floyd.
Just please read what I wrote, thanks.
Thank you. I appreciate it. Yes, we have your letter, 3 pages. Thank you. Oh yeah, thank you. I'm going to ask planning, BMZA, law to respond to this particular concern about what is open to variances. It may actually be a matter of construction that I'm not the boss on.
So I'll take a shot at it and
Pull it up, Becky, just a little bit.
let Becky Witt on behalf of BMZA. So I think it's a fair point. Right now, we have a list of sections of the code that the variance standard applies to. And we're taking that out and saying that variances do not apply to uses. And so that is suggesting that variances could apply to a lot of different things that it doesn't currently apply to. So I think it's a fair point. I don't know what Mr. Tiso thinks. Sorry to go back. So I think on page 8, the top of page 8 of the bill, section 5301B has the current language that says variance procedure applies to changes in bulk and yard regulations, changes in signage, parking and loading requirements. So those are the list of things that it applies to. And instead, it says, the bill suggests that the zoning administrator or BMCA can grant variances from this code, and then it excludes use variances. So it could be opening up the variance procedure to other things in the code, besides just the listed things that are in 5301B right now.
Recess for 2 minutes.
Okay, we're back. Considering the need for changes to a couple of amendments, and everybody generally always being more comfortable with written amendments than orally offering them, in addition to, and also with additional amendment that we need. And I want to give Councilman Jones and Councilman Ramos an opportunity to get together an alternative amendment to be proposed. Before I finish this sentence, was there anybody else that wanted to testify? And nobody online? Okay, great. We're going to hold the bill for 1 week. This committee is going to meet 1 week from today, Thursday, March 27th at 10 a.m. for a voting session. We will not rehear the bill. It's got to be hearing. All right, it'll be a hearing and voting session. Great. We're gonna hold a hearing for the purpose of considering additional amendments and corrected amendments, and to be able to vote the amendments and the bill again, 10 a.m. 1 week from today, Thursday, March 27th. This committee's in recess.
He's gonna send an invite right now.